Father or support person? Support person, we cannot say whether Parmeshwar is can be. He is a villager only. Father of the victim. This is a father's name is reflected. Father's name is Asa to Harry. No.
The mother is Srimati Chokli Mushari, PW11.
Father's name will be there, I think, in the PM's report. In the post.
The PW10, Haita Mushari.
Acha.
Okay, right. In view of the order passed in Deepak Nayak versus State of Assam, Criminal Appeal J40/2020. The father of the victim, that is Shri Haita Mushahari, bracket PW10. No address.
It is there. Moja Ramdev, village Ramdev,
Which 7?
Gosaigaon. Father's name Supur Singh.
Acha, the paper book is this. Haita Mushahari, father's name Supur Singh Mushahari, Moza / village Ramdev, police station, Gosaigaon, district Kokrajhar. Is implemented as respondent number 2. Next part. The additional public prosecutor, Mrs. Jahan, submits that she will scan the paper book and send a copy of the same to the OC
Gosaigaon.
of the Gosaigaon police station, who shall thereafter furnish the same to Shri Haita Mushahari, informing him about the pendency of this appeal. The OC Gosaigaon PS shall thereafter submit a report with regard to service of the notice to the PW2. Respondent number 2. List the matter after 4 weeks. Item 2.
That juvenile part, they'll take it later.
Let notice go. You see, one is the son. The son is the apparent. The daughter, now it appears that the son killed the daughter. The sister. Oh.
And Pokso.
Pokso is there also.
We'll have to see that.
So it's
Very
cannot take this case very lightly.
Unusual, very
Very
unusual.
unusual. Anyway, item 3.
Such a paper book is ready.
Paper book
So it
ready.
will go for
Okay, right.
Pokso now.
Miss R.D. Mazumdar, Madam Amai Ture, and Miss L. Jahan, additional PP submit that they have received copies of the paper book. This is the matter for hearing in the court.
Hello, Blake. Abidu Gurga?
You know, the appeal petition. Appeal copy.
Bail objection is there. My objection is there. As far as Abidur is concerned.
Yes,
Lordship,
yes.
proceeding initiated against a mistaken identity.
Huh?
Proceeding against a mistaken identity, Lordship.
Again, the
Lordship. Accused appellant number 1, Lordship. Abidur Rahman.
Abidur Rahman.
Abidur Rahman.
Abidur Rahman. Mistaken identity.
Lordship, in the Azahar, it is stated that Abidur, son of Munshir Ali. In the charge sheet, it is Abidur, son of Munshir Ali.
So what is the
Wha-
difference?
But my name is not, my father's name is not Munshir Ali, but Amir Ali. I have proved the same before the learned trial court, but learned trial court passed the order. Lordship, kindly have a look at the memo of appeal. Lordship, I have annexed the order passed by the learned court below.
Page.
Lordship, that is a 59. May I read the operative from Lordship?
Yes.
Lordship, today had both the sides on petition number such and such filed by the accused Abidur Rahman to accept the certified copy of the voter list. Also had the learned lawyer on petition number such and such filed by the accused Abidur Rahman Borguya. Said petitioner under section 294 CRTC and the document relied upon is certified copy of the voter list, which is a public document. Hence, prior to rely upon such a document without formal proof is allowed. No other order was passed except this. Lordship, might kindly have a look at the petition filed by the
No, what do you say? What your case is that your name? What is your name?
my name is Abidur Rahman Borguya, son of Amir Ali.
Abidur Rahman Borbuya,
Son of Amir Ali.
son of Amir
Amir
Ali.
Ali.
And
Azahar lost against Abidur Rahman, son of Munshir Ali. I am not the son of Munshir Ali.
there must be alias. Your father might be having 2-3 names.
Not that, Lordship.
Huh?
Not that. It is also not their case also, Lordship. It is also not, even my Lordship, earlier occasion, Lordship, asked for Aadhaar card, Lordship. I have also collected Aadhaar card, Lordship.
And what did the trial court say to that?
Lordship, this is the order passed by the learned trial court. Certified copy was accepted and no other order was passed. And Lordship, kindly have a look at petition filed by the and the Lordship, it is the case of the procedure.
Just a
prosecution
minute,
that
just a minute, just a minute. Yes, then anything else?
Lordship, next aspect, Lordship, kindly have a look at the evidence of the prosecution. Lordship, kindly have a look at evidence of PW3.
Page.
Lordship, it is the record, Lordship, not there in the Lordship memo of appeal.
It's with me.
Yes.
Lordship,
What is this
May-
matter? What is this matter relating to?
Lordship, may I read the evidence of informant that who is the wife of the deceased? And she claimed to be eyewitness.
There was a discussion about something in a school field and there were around 200, 300 people there. And then there was a mob attack. And then these appellants and the deceased as well as his family, they had to leave their house and took shelter in some other place. And this appellant, they went and called the deceased from that place, took him to his own house, deceased house. And there they killed him, assaulted, killed, put the set the fire, set the house on fire, all that facts. It's a mob fight between two groups. But then evidence are against this Abidur and the other appellant also. Others have also filed their
So most
respective.
probably in the forefront of things.
Lordship, kindly have a look at the evidence of PW.
PW?
Three, Lordship.
Yes, what does it say?
Lordship, the informant and wife of the deceased claimed to be eyewitness, Lordship, in this.
PW3 is the informant.
Lordship, and wife of the deceased.
Other bail applications were already rejected in respect of other appellants.
Occurrence took place on 21/5/2006 at about 4:30 p.m. I am the informant of this case. I know all the accused person present in the dock today. They are my co-villagers. This is Don Singh Burman was my husband. On the day of the occurrence at about 2:30 p.m., there was a meeting at Singara High School, Jamalpur. After the meeting, a mob of 200-300 people came at our village shouting, "Kill Burman, kill Burman." Then we, out of fear, took shelter in the house of Madan Kumar Burman. The meeting was conveyed by Jalal Ahmed. When we are at the house of Madan Kumar Burman, PW1, Abidur Rahman called my husband saying, "Doctor, come out." And accordingly, my husband and myself come out to our house. On our arrival, accused Karim gave a lathi blow on the head of my husband, and as a result, he fell down on the ground. And thereafter, the accused Abidur dealt a lenja blow. So, Lordship,
I don't know. Yeah,
according to the informant, there was a lenja blow given by the present appellant. That is accused now appellant number 1, Abidur, Lordship.
Is there anything in your petition charge sheet? Nothing.
Lordship,
Have you put the charge sheet or anything in your petition, in your appeal, memorandum of appeal? Have you put a copy of the charge sheet?
in the memo, appeal memo, Lordship, no, Lordship, that is not. But in the charge sheet, Lordship, his name was given as Abidur, son of Munshira. Lordship, then Lordship kindly come.
In the charge sheet,
Lordship,
in the charge sheet, his name
his
is,
name is Abidur, son of Munshira.
and in the FIR,
FIR Abidur, son of Munshira. All along Abidur, son of Munshira. But he's not the Abidur, son of Munshira. 3 or 4 occasions, Lordship, police could not execute the warrant because there is no such man in such name was found out by the police, and subsequently it was executed by putting a alias by the police while a warrant was executed, not during the course of investigation.
That alias I remember seeing somewhere.
It is only at the execution of the warrant, Lordship. Now, Lordship, her cross part, Lordship, kindly have a look. I did not attend the meeting, so I do not
the
see
problem
what.
is we cannot look. You're the only one with a copy.
Lordship, there, the records are given.
Lordship,
No, what about his basic case is that mistaken identity
Lordship.
due to the name. He
But
said that,
I think
And
in the arrest
another
memo,
aspect-
as he had said in the arrest memo, it was Elias Munshi Ali.
okay, so his father has got 2 names.
Perhaps. That
But
needs to
that
be.
is not. It is put by the police while he was arrested. Only on that pretext he was arrested.
We don't
And
know.
Lordship, another thing, informant lost FIR at first against 7 accused persons. And it was withheld for 1 day and thereafter 7 FIR against Lordship 10 persons. Lordship. So there is a Lordship, there is a concocted story in the FIR. Name how earlier it was against only 7 persons. And
Is there-
Lordship,
you recollect things, sometimes you recollect things which you cannot
but
recollect.
there is a delay of more than 1 day, Lordship, in the lodging of the Azahat. Another aspect, Lordship, eyewitness claimed that he gave a Bollam blow, but there is no
He
decisive
gave a what the blow?
Bollam, Lordship. It is
Bollam,
a-
what is
it is
Bollam?
a spare
Sir, wooden stick.
No, not wooden. It is a lordship, like in their statement that is spare lordship. It is spare.
Spear made of what?
It is iron lordship.
Iron.
Lordship.
So. This
But there is no law, no such
unnecessary-
law in the lordship. Doctor's evidence lordship, kindly have a look. There is a no incised injury, only lacerated injury. Lordship, may I read the evidence of doctor?
What do you understand by the word lacerated?
Lacerated lordship, where
Let us see, give us the dictionary.
Lacerated also kinds, bruises kind.
lordship only lacerated injury, but that cannot be caused by a lordship ballon blow.
Why not?
That-
Why not?
No, lordship,
Who
no,
said?
not possible, not possible.
Have you ever used a ballon?
No, lordship, it is from the lordship, it is clear from the lordship, some of the judgment.
Are you saying it from
Lord-
your personal
I'm-
experience?
Lordship, I am relying on the some of the judgment of the apex court, lordship. That is not possible by a ballon.
Why not? If you-
Lordship, I am
supposing-
relying, that's why I am lordship, in
Supposing,
support of my lordship argument, I am relying some of the judgment of the apex court, lordship. And the lordship,
my God, what do you think? You're giving us this many-
lordship, I have
this-
also lordship quoted the
You-
relevant
no,
paragraph.
you-
kindly
you-
have a look.
You tell us, you cite which case?
Lordship,
We're not just going to read just for the sake of reading. You tell us which particular case, which specific case.
lordship, 1997, 75, 4 SCC,
1997,
1975, 4 SCC,
1975, 4 SCC,
511.
511,
Lordship,
para,
lordship, 9.
what does it say?
Lordship, I have quoted
no,
the
you say you read.
lordship. According to the evidence of this witness, the two appellate Golab Singh and Joginder Singh appeared to have assaulted Gurmesh Kaur with sharp cutting instrument, namely Borsha and spear. This version is completely falsified by the medical evidence. Such and such, who examined such and such, were caused by blunt open. Moreover, out of the 6 injuries which Gurmesh Kaur received on her body, not a single one could be caused by the sharp cutting instrument, because there was no penetrative or incised wound. The injuries were either contusion, abrasion, or lacerated.
Now, Mr. Counsel, let me ask you.
Lord.
Can a person use the handle of a spear as a weapon? Or does it have to be the pointed part of the spear? Supposing this is the spear. You hit someone with this part. Can you use it as a weapon, this part, or does it have to be used this side of it?
He also can use just that part also. But it is their statement is that he gave a bollam blow. So-
Blow means what? Blow means what? What do you understand by the meaning of the word blow?
Blow like
Blow, this is not blow, this is not blow. You pierce someone with a spear, or you throw a spear at someone. When you give a blow, there is like this, like a cricket bat, like that, or like a baseball bat.
and another lordship. So these are only for supporting my mistaken identity part, lordship, that their ocular version is not supported by the medical evidence. Second, lordship, judgment, lordship, kindly have a look at 2011 Criminal Law Journal, Madhya Pradesh,
2011,
Criminal Journal 3843,
3843,
Madhya Pradesh.
3843.
Lordship 3843.
Huh.
Moreover, out of the 9 injuries which Jala Prasad received on his body, not a single one could be caused by sharp cutting instrument because there was no penetrating or incised wound. The injuries were either lacerated wound or abrasion. Thus, the aforesaid discrepancy in medical evidence and ocular evidence amounts to a fundamental defect in the prosecution case and is sufficient to discredit the ocular evidence. So, Lordship, I
Now
rely.
you see, I'll just give you the dictionary meaning of the word laceration
Lacerated,
or lacerate. Lacerate.
lesser,
Please listen. Lacerate means tear or deeply cut
Yeah.
or deeply cut. The point had lacerated his neck. And laceration means it's a noun, a deep cut or tear, especially in skin, a gash. So laceration is a cut. If you don't believe it, you please argue with
but
this
Lordship,
Oxford Dictionary English, whoever this fellow is.
no, Lordship, that is true.
That
But the cut injury that may be, but even Lordship, size of the cutting.
this, the medical report is supporting the prosecution. You're trying to twist it around.
Fracture is there,
No, there's laceration, there's deep cuts.
deep cuts.
So that points to the spear.
But that may not be also a spare Lordship.
Now you
But
said-
Lordship, Lordship kindly have a size of the injury, size and length. That cannot be caused by a Lordship instrument like a spare. Lordship,
Are you
Lordship, I am submitting your it is up to your Lordship.
no,
next one-
no. When you submit something,
Lordship,
you see, it has to have some meaning.
Lordship.
You cannot.
But
you
these are the
cannot
two judgments in my favor, Lordship.
these are
These
not in
two,
your
there is
favor.
a clear finding in these two judgments that cannot be caused. So I am relying on these two.
Okay.
Lordship. Next, Lordship, judgment of our High Court, Lordship, regarding delay of the filing of the Azahar and why there is a two Azahar and delay of 1 day in a.
Mr. Counsel, we cannot have a full length hearing
Lordship, that is
on minute details.
Lordship.
You see,
Lordship.
you have already been convicted.
Lordship.
So please go to the very relevant facts.
Lordship, that
Very
is,
a prima facie, which is discernible.
so my Lordship, my primary Lordship submission is Lordship, mistaken identity. That is not proof, no way. And in that context, I rely to judgment of the one of Lordship Calcutta High Court, Allahabad High Court, and another Lordship Supreme Court. Regarding the identity, Lordship. Lordship one, Madhya Pradesh, and another Lordship Allahabad. It is their stand that their prosecution witnesses familiar with
Which one are you reading?
Lordship, no, I am not. I am reading from the Lordship. Lordship, kindly have a look at para 25 of the. I have noted at the top of
Okay,
the citation.
okay.
Para, relevant para.
25.
Lordship. That is in respect of dying leave clearation. For my last submission, Lordship, withholding of the first FIR. First FIR was withheld, and why it was withheld? It was not
Was
explained.
your name in the first FIR?
No, that was withheld by them all along, Lordship. And Lordship, in this case, I am relying one of the,
No, no,
That-
where is the proof that it was withheld by them?
yes, but PW3 admitted.
Where?
Lordship, it is in her evidence, Lordship.
What does PW3 say?
Lordship. May I read the live, Lordship? I filed FIR regarding 7 persons, and there are other villagers around our village and people stayed there. At first, she named only 7 persons in the Azahar that was withheld, and subsequently,
How do we know that your name was not there in the
but
seven?
it is their burden. My name was there in the first FIR. Why it was withheld? It was.
Your name was there in the first FIR.
It has to be proved by the prosecution side.
No.
My name is not there.
That-
My name, I am Lordship. I am now 71 years old man, Lordship. There was a mob fight. Old man of 60, 70. Is it possible?
Why not? PW1 in fact says that you hit him also.
That's why he is to identify clearly. He
Yes.
ought to identify me.
He has
Lordship.
identified you.
But not even court also he could not identify me. Even court also. That was the finding of the court that he identified. But Lordship, kindly have a look his evidence. Nowhere he identified. Learned
next.
court below came to a finding that PW1 identified.
Okay.
You have that challenged the identity of the person while cross-examining. No,
Lordship-
examine the witnesses, because they, all the witnesses are really pointed you that you get with Balram. But
Lordship,
you have not cross-examined or not put any suggestion to
that,
the witness.
that is their burden, that
No, no,
case
no,
against
not
me.
burden, I'm
No,
not on
it is
burden.
their burden.
No, I'm not on burden. You have not challenged that identity,
Not-
even in
That was
cross-examination.
not challenged, but
Why you
that
have
may
not
be
challenged?
Lordship.
Why-
But it is their burden, Lordship. I am relying judgment of the honorable court, Lordship. It is the prosecution, it is their burden with the cross, no need to
Okay,
cross.
I think,
Only-
anything else?
Lordship, consider Lordship may either accept or I leave it to your Lordship.
As far as the marriage is concerned, there are 8 eyewitnesses, in fact, and everyone has named both these appellants who have hit him. He was the one who brought him and then hit him. So as far as marriage, there is enough materials. And mistaken identity, as the lordship had said, nothing, nothing in the cross. Even in 313, he did not say, I was not that person. He simply denied all his questions. And then now taking that plea, and trial court has
it-
already gone into.
It is also taken in the trial court also.
No, no, one
Trial
thing,
court
in
has
the
gone
313, in the 313,
Lordship at first that
no, no,
was,
please answer the question.
Lordship,
In the 313, did you take the plea or explain that they have caught the wrong man?
that was 313, no such question was put, but no-
He had the opportunity to explain his case.
but it was subsequently I have taken plea. I have filed the petition, that's why.
Subsequently, after 313,
It is, I'm not sure. Application was filed, Lordship. Date, Lordship, I have annexed the application, Lordship, in the.
before the trial court.
Before the trial court. Lordship, kindly have a look at,
313, I'll tell you when is the this record.
Okay, anyway,
Lordship,
yes.
it is 53.
Huh?
Lordship, 53 of the appeal law. Everything was stated, grounds were stated in his petition, Lordship. I have stated all those grounds. It is only first time came to his notice during the statement recorded under section 313, Lordship. That his father's name is not matched, his name was not matched, and thereafter he filed the petition.
Where have you said it? Where have you
Lordship,
said-
para 5, page 54.
In the 313, his father's name is Amir Ali, not Munshi.
Huh?
313, his father's name is reflected as Amir
But
Ali.
it is not
He is
there
that
in the,
person.
it is not there in the Lordship FIR, charge sheet, or in the while charge was taken.
He is the one who was examined.
That
And
may
he
be,
was
but it was given by him. It was given by him. It is not the Lordship case.
Okay.
It was given by him while statement was recorded. So prosecution is missed the 2 names.
So you say that there is discrepancy in the name of the father of the petitioner.
Hmm.
But he does not, you do not say that you have been wrongly arrested.
No,
There
this is nothing of
You are
that
only
sort.
saying that there is a discrepancy in the name of your father.
That is not
It's
a
not
job.
your case that you are not the person that whom they want, I think. That is not your case.
Lordship,
Is
that
that
is also there.
That is,
That is also there. That is also there.
so there are too many things.
Lordship.
Okay, right. Heard Mr. L.R. Mazumdar, learned counsel for the applicant. Yes, madam, what have you got to say?
Lordship, my submission would be only that married, he has no case. And a mistaken identity, it's already in the arrest memo that it was Elias Munshi. And 313, he did not take any he did not make any statement. There was no cross-examination on that part. Cross-examination was done separately as far as Abidur is concerned. No question, no suggestion, nothing.
Okay, then the bail application of the others have been,
Others were rejected.
with IA,
IA numbers are not reflected. But they were all rejected. In respect of Botol Ali, everyone,
okay, right,
Chandu Mia.
okay. And Mr. L.R. Mazumdar,
Don't
learned
numbers
counsel
must be
for
there.
the applicant. And Ms. S. Jahan, learned additional PP. This application has been made under section 389 CRPC for suspending the sentence imposed upon the applicant along with two other co-accused, who have been convicted by the learned trial court. That is the additional sessions judge, FTC HR, Silchar. In sessions case number 104/2011. Under section 148/448/302, read with section 149 IPC. The applicant, along with the other two co-accused, namely Chandu Mia Laskar and Salim Uddin Laskar, have been sentenced to undergo rigorous imprisonment for life with a fine of rupees 5,000, in default simple imprisonment for 3 months under section 302/149 IPC. They have also been sentenced to undergo rigorous imprisonment for 1 year with a fine of rupees 5,000 each, in default SI for 1 month under section 148/149 IPC. They have also been sentenced to undergo. They have also been sentenced to pay a fine of rupees 1,000 and ID SI for 1 month under section 448/149 IPC. The applicant's main ground for suspending the sentence is that his involvement in the case has been made due to the police having mistaken his identity for another person. He submits that the applicant's name is Abidur Rahman Barbuya, son of Amir Ali. However, the person who should have been arrested in the case should have been Abidur Rahman Barbuya.
Abidul Rahman, Lordship, son of Munshir.
Abidur Rahman, son of Munshir Ali. In terms of the FIR submitted by the informant and the charge sheet filed by the police. He also submits that though the evidence against the applicant is that he had hit the deceased with a balam, BALLAM, bracket spear, the injuries not being cut injuries, there was no question of the spear being used as a weapon to hit the deceased. he also submits that an FIR had initially been submitted having 7 names, containing 7 names. However, the same was hidden. Hidden by whom?
Lordship, it is PW3 and
However,
the police,
huh?
both are involved.
However, the same was hidden by PW3 and the police. So no one has seen it,
Nobody.
and no one has seen it besides PW3 and the police.
PW3 also admitted before the
Yes,
time.
Mr. Counsel, are you a lawyer?
Lordship, I don't know about 5.
Are you a lawyer? Where is your ban?
Forgot about that.
No problem, no problem, no problem. You go and wear it. No problem, no problem. Just wear it. Huh? Ha. So where are we? And the police. So that means even you have not seen it.
Lordship,
Or you have seen it.
no.
The applicant's counsel submits that even the applicant has not seen the hidden FIR, which has been hidden by PW3 and the police. Full stop. He submits that subsequent to the above hidden FIR, a subsequent FIR was filed by whom?
PW3.
By PW3,
After about
containing 10 names, including the name of the applicant hearing. The second FIR was filed 1 day after the first FIR was filed. He submits that no explanation has been given as to why a second FIR was filed. After
and
the delay of
Lordship, another Lordship,
after
there
the-
are 16
after
accused.
delay of 24 hours. Thereby raising an inference that the second FIR was a fabricated FIR. So only you know about that second FIR. No one else knows.
That Lordship,
There
Anyway.
was a GD entry in the beginning. They
How does it
informed-
matter, madam?
Yes, they informed it through telephone.
He
there was a
doesn't,
GD.
you see,
Ah,
the thing is that something which he only knows,
uh-huh.
he'll have to prove it.
Yes.
If he says that if he says that actually President Trump is a black man, well, if he's the only one who knows it, he'll have to prove it.
Otherwise, the facts are
Lord-
like initially there was a GD entry.
Holding
there.
of first FIR itself is a Lordship, whether believable,
Huh?
the prosecution story.
What?
First FIR was withheld by the prosecution and second FIR
No,
was
no.
lost. Is it saying whether second FIR is believable, Lordship? That is my submission. Why it was withheld and
Is there, where does it say that it was withheld?
yes, it has withheld by them.
Where does it say it has been withheld? Is
Uh,
there any proof?
Lordship, it is admitted by PW3 in her evidence before the court
She says what?
that I have lost FIR against 7 persons. And subsequently, this FIR was lost after 1 day against Lordship. It is I am not wrong, Lordship, 21 against 21 accused person. First FIR against 7 and second one is against 21.
Now you're making it to 21. Earlier you said
Lordship,
10.
I have earlier.
No, anyway, no, we cannot hear. You cannot keep on making up your case. Anyway, right. He accordingly submits that that in view of the discrepancies stated above, the sentence should be suspended And then the applicant should be allowed to be released on bail. So, next, Ms. El Jahan, additional PP. On the other hand, submit that the arrest memo pertaining to the applicant shows that the applicant's father's name was shown as Munshir Ali, alias Amir Ali. She further submits that the evidence of the doctor clearly shows that there were cuts on the skin of the deceased. And as such, there is nothing, and as such, the wounds
7%.
support the theory that as the spear used by the applicant had caused the injury on the deceased. She further submits that though the applicant had the opportunity to raise the issue of a case of mistaken identity having occurred during his examination under section 313 CRPC, the applicant has not given any explanation during his examination. Any explanation to that effect, Full stop. She also submits that the prosecution witnesses were not cross-examined on the issue of the petitioner being arrested in a case of mistaken identity. She accordingly feels that the application should be rejected. Full stop. We have considered the submissions made by the counsel for the party. And on a cursory look at the documents on record, we find that the doctor's evidence shows that. Where is that page?
Doctor is PW 11.
Injury. What have I said? Shows that he had found multiple lacerated injuries present over the scalp, and multiple abrasions were present. It was the opinion of the doctor that death was due to coma resulting from head injuries. And all the injuries were antemortem and caused by a heavy, sharp cutting weapon. Which was further, as per the definition of the word lacerated as given in the Oxford Dictionary of English. Lacerate, lacerate. It means tear, T-E-A-R, or deeply cut. Full stop. Next paragraph. The applicant at the time and the applicant's arrest memo shows that his father's name had been recorded as Munshir Ali, alias Amir Ali. Full stop. Further, no explanation was given by him at the time of his examination under section 313 CRPC. To the effect that his arrest was a case of mistaken identity. His arrest and involvement in the case was a case of mistaken identity. A cursory look at the evidence also shows that he did not, that the applicant did not confront the prosecution witnesses, that his involvement in the case was due to a case of mistaken identity. Next paragraph. The above being said, we also find that the applications made by the co-accused for suspension of the sentence and grant of bail have been rejected by this court. As such, we do not find any ground to allow the present petition. The application is accordingly rejected. Consequently, prayer for bail is also rejected. I accordingly disposed of.
22 matter paperwork.
So right in the main appeal, you write, in the main appeal, 11122, you write, as LCR has arrived, registry to prepare the paper book. List the matter after preparation of paper.
After 4 weeks.
Oh, list the matter after 4 weeks.
After 4 weeks.
List the matter after.
Like,
You can take back your judgments. So many of them.
That's why beg apology for.
No problem.
Improper dismissal. In item number 5 and 6, my lord, there was a direction to take steps after being impleting the informal mallet.
5 and 6?
Item number 5 and 6. my lord. Here, okay.
Analogous matters.
Another
Steps for what?
steps for impleting the my lord, notice were issued to the informal mallet. Here.
Not
Not
required.
required, not required.
Otherwise, there was a direction by this honorable court.
Just give me add 5 and 6.
Compliant to that.
The wife is the informant. No.
Wife is the informal.
Not
Wife is
required.
the deceased.
But this court order is already there, what to do?
Otherwise, IA has been disposed of, my lord.
There is an order for impleading. So they
Impleading,
have,
Yes.
You have
compliant to that one.
they have filed
Compliant to that order, my lord, we have taken steps. There was an order for impleting the informant, my lord, in item number 5.
the
That has been
impleading
done.
application.
In
for-
contact.
Oh.
Steps were also
So
been,
let it take its own course. Let the police go in.
there's a direction for preparation of the paper. Let the matter may come up for the for hearing, my lord, together.
If the report.
No,
comes-
impediment of whom?
Informant,
This court had directed.
this court had directed.
Let a report come, if you let, then lordship will dispense with.
Paper book has not been made. What can I,
Paperwork.
as paper book has not been prepared, this is the matter after 4 weeks.
Highly.
In 98, huh? 98 of 2020.
Criminal appeal 100 is also.
100 also there.
100 also same.
Same.
Item 6. Actually, you don't need to pass it. Anyway,
There was a direction.
One paper book
Yeah,
will
right.
do.
Ah,
One paper book only.
yes,
one paper. And logo.
100 you don't write anything. 100 don't need, because it will take care.
It will follow.
Highly.
Yes, are you filing anything?
No, 7 perhaps this has come for the first time, the bail application. Yes. Yes, this has come up for the first time. I think. I,
Okay, right.
I'll take,
In the criminal appeal, you write. As the LCR has arrived, registry to prepare the paper book to establish the matter after 4 weeks. Then in the IA, you write Ms. S. Jahan, additional PP is granted 4 weeks time to file WO. This is the matter after 4 weeks.
4 weeks time, lordship. No, no,
Yes.
no, just put on a- put on a- 60. Item 8. Sir, LCR is here.
So, right, as LCR has arrived, registry to prepare the paper book.
My lord, in this matter, notice has yet to be issued. On last order, I have checked the file, my lord.
No, 302 not required.
Okay.
Uh, This is the matter after 4 weeks. So,
Lordship.
make paper book.
Item number 9, there is an office note saying that I have not taken steps, but the problem is by the order, by your lordship's order, I was supposed to send it through the OC to the respective victim.
Ah.
That I have done. That
Yeah,
I
where
have
is the
sent
report?
through the office, but the report I don't have.
So you,
So
if you can give the report, then that's enough.
Lordship, we will take it up on Monday then.
We get-
Monday I'll get the report. I've already spoken to the OC. He said I have sent it, but where he sent it, I'm not getting it. So Monday I'll get the report.
Okay, right, Ms. El Jahan, additional PP in the main appeal, in the main appeal, Ms. El Jahan, additional PP submits that the OC of the concerned police station has sent a report
Hmm.
with regard to the
Kokrajhar,
issuance of
Amulpur, yes.
the scam, the issuance of the notice.
Yes.
No, with regard to information being given to the victim slash guardian. No, guardian,
Got it.
regarding the pendency of this appeal. She accordingly placed for time to obtain the necessary
Report.
report. This is the matter on
On Monday,
Monday.
Lordship. Monday, 9th, Lordship.
9th.
Pune.
But there is a IA also.
In respect of IA only, I think that notice was issued.
No, in the criminal appeal.
IA, yes, I have filed my objection.
Yes, yes,
I have filed my objection long.
in
back,
the
but
IA, yes.
it will
What
be
is,
in the
what have you
record.
got to say? In the IA.
I hold on. No, objection.
Section 6, POCSO Act.
Even in bail, I think the victim needs to be heard. This is what, but.
No, it depends if
Depends
it's
also,
only
yes.
going to allow that one.
Huh.
You tell us.
Lordship.
My lord. Huh?
Thereafter, lordship, interception was made from 4 accused person in front of the gate of services and lordship. Interception was made there and recovered opium and
How much
More-
opium?
opium 54 kg lordship,
How much?
54 kg lordship.
54.
54 from 4 accused lordship,
54 kgs
kgs lordship.
from one bag,
No, from 4 person,
4 persons,
4 persons hands lordship,
4 persons' hands.
lordship.
They were carrying it openly or in a bag or
In a
what?
bag, actually story is that like that lordship. After receiving the information, they saw that the one Scorpio vehicle was standing in front of the gate of the Porkozai Stadium. Then lordship, one truck came. Then two person earlier inside that vehicle, and then when the truck came, then 2 person deboarded from the truck, and they for 1 minute they talked with the other 2 person who were already there
In the Scorpio.
in the Scorpio. Then lordship, what happened? One person entered inside the truck. He brought some packets and then handed over to the other 2 person who were there. Then at that time, the interception was made.
How many packets? What packet?
4 packets, lordship,
4 packets were brought out from the truck.
lordship. And then 2 kgs of morphine from Mazibur Rahman. Truck.
2 kgs morphine.
Morphine,
2 kgs from
Mazibur Rahman. lordship.
Mujibur Rahman. No, Mujibur Rahman, yeah.
Lordship. In this case, lordship, thereafter, final complaint filed by the
So who was sitting in the Scorpio?
Scorpio, as they alleged, Saurabh Khan and Ram Milan. Saurabh Khan in appeal number 393,
Just a minute, Saurabh Khan.
and Ram Milan lordship. He is in 360, criminal appeal number 360.
Ram Milan.
Yes. Then in the truck was Abdul Kalam and Mazibur Rahman lordship.
But, okay, Mujibur Rahman.
Yes.
Now, just tell us one thing.
Lordship.
In item 18,
Yes.
it is said Shri Ram Milan and another. Who is this another?
Another is lordship Abdul Kalam.
Abdul Kalam. Okay, so but Abdul Kalam, okay.
Abdul Kalam in the truck, and then Mazibur Rahman is they allege that the owner of the truck also. The Scorpio vehicle subsequently that was seized or not, that is not established by the prosecution. We'll come on that later on also. Then what
But
happened?
then if that is the case, why have Ram Milan and Mujibur Rahman filed the same appeal? Ram Milan is from the Scorpio.
Mazibur Rahman is different appeal lordship, that is 288.
No. Ram
Was it
Milan.
Ram Milan and Abdul Kalam in the same appeal.
Okay, so that is what. But then the appeal had been filed by Ram Milan and Saurabh Khan. No,
We have not filed in that way, lordship. Actually, whoever come first, then accordingly we file. There is no intention to file
okay.
out of same judgment, lordship. So in this case, what happened, lordship, they filed a final complaint, and then cognizance took place by the learned trial court. That
Final complaint under which section?
under section 17C 29, lordship.
No, under which CRPC?
17C of NDPS.
That is Indian PS.
Yeah.
It is a complaint case or not?
Yes,
Then complaint case filed under which CRPC provision?
section 200, lordship.
200,
Lordship. Complaint, lordship, as the office,
200.
lordship.
Okay, then
Then lordship, cognizance took place by the court, and the charge came under section 17C/29. Charge head is at page 3, page 3. It starts from page 3.
17C.
17C. Oh, sorry, lordship. It was framed under 8C under section 21C and then 29, Lordship.
Charge framed under
The 8C
8C
and then 21C, Lordship.
and 21C.
21C and 29.
21 is heroin.
That is why, Lordship, we have taken the plea and we have filed additional grounds in this case, Lordship. And
Charge framed under 8C and 21C.
21
That's all.
and 29.
And 29.
But that was not rectified by the trial court at the time of during the trial, Lordship. So conviction was there.
Conviction under
17C, 21C and 29.
conviction under 21C,
17C,
17C,
21C
21C,
and 29.
29.
Lordship.
17C is opium.
Opium.
Then morphine will come under
Morphine will come under, I think 22,
22.
22.
Psychotropic.
Yes. No, then
So what was seized? Opium and morphine only.
opium and morphine, Lordship.
Let us see the schedule.
Yes. Opium, Lordship will get serial number 92.
77. Oh, no, yes,
92.
92 and morphine at 77.
Yes. Undoubtedly, Lordship, it's a commercial quantity, Lordship, allegation against the appellant's, Lordship. But what happened in this case, we have to explain that thing, Lordship.
So let us,
Conviction is about
let us
20,
see, let us see morphine comes under which section.
Lordship. Punishment for contravention of.
Morphine will come under which? No, 21, it will come under 21. No. See, no.
Punishment for Lordship, it will come 21, Lordship.
Heroin will come under 21
Yes, Lordship.
and morphine will also come under 21.
Yes, Lordship. Manufactured drug and preparations.
Manufactured drug. No?
Yes, Lordship.
Because let us see what is the definition of
The
psychotropic
manufactured drug
substance?
definition is there, Lordship.
Huh?
Manufactured drug definition is there at 11, Lordship. Definition. Manufactured drugs means all cocaine derivatives, medicinal cannabis, opium derivatives, and opistrog concentrate. Any other narcotic substance or preparation with the central government may by having regard to the available information as to its nature or to decision if any under international contribution by the notification of in the official gazette declared to be manufactured done. But does not include any narcotic drugs or preparation which central government may by having regard to the available information as to its nature to a decision if under any international convention by notification official gazette declared not to be manufactured. Notification is there to that regard also. Maybe it will come, morphine will come under that also.
The notification is only with regard to this, the schedule is only with regard to, in the act, only with regard to, psychotropic substance.
Yes.
There's nothing with regard to manufactured drugs, I think.
But regarding morphine, there is notification like heroin, like that, Lordship. There another notification is there.
Where is that?
Yes, I have that one.
Yes, is, any B Acharya, M Acharya, are they here? You are there? Okay. You are in that matter, that last item. Okay. So yes, finally turned up.
Lordship, Lordship, 1/89 notification is there. It is mentioned in this.
Yes, sure.
Morphine in the second column. Lordship. Narcotic drugs.
No, it's a narcotic drugs, no doubt. But why will it come under 21?
21.
Because opium comes under 17.
Yes.
There's specifically 17 is there for opium.
Narcotic drugs definition. is there.
You see, because another thing,
Hmm.
narcotic drugs, when you say amphetamine will be what? Amphetamine will be, I think, psychotropic.
Lordship, kindly go through the definition of narcotic drug. Lordship. It is explained there. Narcotic drugs means coca leaf, cannabis, hemp, opium, poppy straw, and including all manufactured drugs. That is why 21 will attract Lordship.
No, madam, you see, there is something, this is our weight, 91 or what, 1990 or what,
In 89.
89, that was long time back. I think,
It's-
I
it
don't think this is up to date. You see,
No, it is.
I'll tell you why.
Lordship.
Please come to that second part of the page, second page of the same notification.
Yes,
You see on top, it's number 3.
Yes.
Amphetamine,
yes,
correct?
Yeah.
Now amphetamine is along, it comes on, okay, that's a different, it's a psychotropic, it's
so-
clarified there, okay,
so far my knowledge was, Lordship, this notification still prevail.
okay. Anyway,
Lordship.
okay, I just want.
And now in the year 2022, in December, Lordship, another notification come into play, Lordship. That is not applicable to this case. That is why I didn't bring that, Lordship. That is same, Lordship. Little bit changes are there. So, Lordship, in this case, can I go ahead?
Yes.
Lordship, in this case, what happened, Lordship? After in final complaint submitted, in the final complaint, 6 witnesses cited as witness in their witness list, Lordship. And final complaint, Lordship will get that.
No, let us leave that aside. Now, what is your ground of challenge?
My ground of challenge in this challenge is in this case is, Lordship. All the official witnesses are there, and the mandatory provision for 52A has not been complied by this in this appeal, Lordship.
So section 52A not complied,
And Lordship, and another mandatory provision. is
52A2,
50, yes, Lordship.
52A2.
Lordship.
Then
And thereafter, Lordship, 50 is their mandatory provision, though the bags carried by in hand, but latest apex court judgment is that if from body, after search of the body, if not recovered, if body search, then 52 will come into play, Lordship. That is the latest full bench judgment is there, Lordship. And place
full bench judgment of which court?
apex court, Lordship.
Is there a full court of the apex court?
Lordship.
How many judges?
Five judges, Lordship.
That is not a full court, Mr. Alvin.
Larger bench,
That is a constitution bench.
Constitution.
Not a full bench.
sorry, Lordship. So
And I let me see, I don't think so. I don't know.
I'll place accordingly, Lordship, one by one, so that I can,
Okay, so one is section 50 not complied with,
not comply.
not complied with.
And- Then, Lordship, two
Third-
official witness, the two independent witness, they have stated categorically that the two in front of the two independent witness, they have recovered all the things, search and seizure done in presence of the independent witnesses, Lordship. But they served a summon to these witnesses, and someone returned that in that address, though no person available, Lordship.
The two witnesses not available.
Not available and not exam, and the court, honorable court, learned court below asked the question to that regard, and they gave the time to the prosecution to place to that regard regarding the witness. But they did not submit any report to that.
there's a possibility that you might have bought them off.
No, Lordship, they are
So
inside.
to have 52 kgs of opium is not a small amount.
They are inside and they are not from Assam, Lordship.
It doesn't matter. They're everywhere.
An official, Lordship, actually, to my information, they are official person, that is why.
Drugs is the biggest illicit or illegal crime in the world. I think involving around $360 billion a year. Second come arms. Third comes human trafficking. Fourth comes your animals, exotic animals. So it's not a small amount. Anyway, that
But the prosecution also did not try to bring them before that court.
if they are not there, why
But
will
in
they
the
be?
address, in that address, that person is not available, that report. Yes.
Was it their permanent house or was it a rented house?
But they have stated in their final complaint, these are the permanent address and permanent person of this address, Lordship. So our suggestion was that they are the pocket witness and official person. That is why they could not bring this person before the court.
And
The
then
IO could have,
if they were professional witnesses, they would have surely come to the court.
they are not professional at all,
That's
but they are the official of the NCB department, Lordship. That was the contention.
If they are NCB officials, Then they are not independent witnesses.
We could not prove that right now that they are the official witnesses, but our suggestion was like that, Lordship, in the court below.
Okay.
So this is the case.
So that is suggestion only. There's no
Sir,
proof.
Yes, we could not prove that, Lordship. So in this case, Lordship, there are no independent witness, only the official witnesses, and the only PW3 is the seizing officer, and his presence is there, and the PW5, the investigating officer. These two persons,
Oh, PW
PW3
3.
and the PW5.
He is the seizing officer.
He is
PW
the seizing officer,
and PW5
PW5.
is IO.
I
So the entire evidence
enter
conviction based on their
their lordship. Only this person, but others are there. They have stated that though we are there, but we did not put any signature. We are not the witness of the Caesar lordship. That was there regarding the other witnesses. Here in this case, lordship, PW1 is the FSL expert. So,
PW1 is the FSL.
yes, lordship, scientific officer lordship, and 2 is Tulika Morang, superintendent lordship, NCB.
Superintendent of CB.
NCB, and C was the in charge of the godown lordship. Three is seizing officer Pawan Baisani.
Yes, then
Then 4 is Suresh Kumar Singh. He was the team member at that time, lordship,
team member is CB.
NCB.
Yeah.
Five is investigating officer, Anjani Kumar, and then Praveen Kumar lordship. Praveen Kumar is the deputy director at that time, zonal director at that time, lordship, who issued the
Deputy director.
director of NCB lordship.
And so the independent witnesses were not there.
Not examined by the, though their names are there, lordship.
Can you put on the receipt?
Lordship, we can go directly to the PW3 first. Here's the seizing officer.
Page.
Page 13, lordship. May I start, lordship?
Yes.
On 6/5/2016, I was working as intelligence officer in the Narcotic Control Bureau, Guwahati. On that day at about 5:30 p.m., I received an information from my informer that 2 persons, namely Mohammad Abdul Kalam and Majibur Rahman, would be going to deliver a consignment of morphine and opium to 2 other persons, namely Saurabh Khan, Ram Milan near Indira Gandhi Sources, Guwahati. On that day, immediately after receiving the information, I reduced the same into writing. It was informed to my superior, namely Tulika Morang, superintendent NCB Guwahati Zonal Unit. After that, an office order was issued by the Zonal Director, namely Praveen Kumar, deploying 10 persons worked the operation. I myself was seizing officer as per the said office order dated 6/5/2016. Exhibit 3 is the NCB 1 reduced into writing, wherein Exhibit 3(1) and 3(4) are my signatures.
What do you
Exhibit
mean NCB1? What do you mean?
NCB 1 is the information received
Okay.
by them and reduced into writing, lordship. Exhibit 4 is the said office order. Then, lordship, on the next day, that is 7/5/2016, as per office order, we left NCB office at 6 a.m. after reaching near Indira Gandhi Sorosai, Guwahati, Indira Gandhi Stadium, Sorosai, Guwahati. We approached 2 persons who were walking on the road and told them about the information available with us. We also give our introduce of our members of the team and requested both of them to be independent witnesses of the process of search and seizure, if any. When we reached the spot, along with independent witnesses, 1 white color Scorpio vehicle bearing registration number was seen parked on the service road. At about 6:30 a.m., 1 truck bearing registration number reached near the Scorpio. After that, 2 persons from Scorpio came out and went near the truck. The two persons who were sitting near the truck also came out, and these four persons discussed something for about 1 minute. At that time, the team was indicated by the informer that these were the four persons who were trafficking the opium and morphine. After that, one person entered the cabin of the truck and handed over a few polythene packets to the persons who were standing near the truck. We rushed towards the truck and the Scorpio. When we reached near the said vehicle, all the four persons were standing near the said truck with polythene packets in their hands. Thereafter, we introduced ourselves to them and we told them about the information available with the team. On asking the four persons, they identified themselves as Muhammad Abdul Kalam, Mujibur Rahman, and Muhammad Saurabh Khan Ram Milan. These four persons were present near the truck. During body search of the four persons and their belongings, provisions of Section 100 CRPC were followed. Before conducting body search, I served the notice under Section 50 of NDPS Act to all the four persons. They acknowledged the same and gave the written consent of the body search. Exhibit 10, 11, 12, and 13 are the acknowledgement copy of the body search issued to them under Section 50 of NDPS Act. Thereafter, the said four persons gave written consent in presence of the independent witnesses. The written consent of four persons specifically stated that they did not need the presence of any magistrate or any other gazetted officers at the time of body search. Exhibit 4 is the relevant consent given by the accused Saurabh Khan in his own handwriting. Exhibit 5 is the relevant consent given by the accused Ram Milan in his own handwriting. Exhibit 16 is the relevant consent given by the accused Mujibur Rahman in his own handwriting. Exhibit 17 is the relevant consent given by the accused Abdul Kalam in his own handwriting. On opening the plastic bags carried in both hands by the accused Saurabh Khan, dark brown color sticky materials was found packed in two packets wrapped by brown color sellotape and kept in white polythene packets. A small quantity of dark brown color sticky material was taken out from both the packets and tested with the help of drug detection kit brought by the NCB team, and both materials gave positive for opium. Both white plastic bags were marked as C1 and C2, and packets containing dark brown color sticky materials were marked as P1 and P2. On weighing with the help of digital weighing machine in presence of two independent witnesses and four suspected persons, and weight P1 and P2 was found to be 10.128 kg and 10.148 kg respectively. The opium was seized in presence of two independent witnesses and four accused persons. Drew one sample in duplicate to 24 grams each and marked as S1, D1, S2, and D2 respectively. All the four samples were duly packed in polythene and then kept inside an envelope. All the samples and seized drug brown color sticky material suspected to be opium was sealed with NCB brush seal number 1 and properly labeled, and signature of the independent witness and four accused person and seizing officer were also taken on them. The polythene bags carried by Mujibur Rahman was searched, and opening the said bag carried by him, dark brown color sticky materials was found in one packet wrapped by a brown color sellotape and kept in white polythene. A small quantity of dark brown color sticky material was taken out from the packet and tested with the help of drug detection kit, and the material gave positive color for opium. This white plastic bag was marked as C3, and packet containing dark brown color sticky materials was marked as T3. On weighing, the sticky was found to be then the opium was seized. Then we drew one sample in duplicate of 24 grams each in presence of independent witnesses and four accused persons and marked as ST and D3. The sample were duly packed in polythene and then kept inside on the envelope. All the samples and seized dark brown color sticky material suspected to be opium was sealed with NCB brush seal number 1 and properly labeled, and signatures of the independent witnesses for four accused person and seizing officer was also taken. The polythene bags carried by Ram Milan were searched, and on opening the plastic bags carried in both hands by Ram Milan, the dark brown color sticky materials was found packet in 2 packets wrapped by brown color sellotape and kept in white polythene. All small quantity of dark brown color sticky material was taken out from the both packets and tested with the help of drug detection kit, and both materials gave positive for opium. Both white plastic bags were marked as C4 and C5, and packet containing dark brown color sticky material were marked as P4 and P5, and weight for P4 and P5 were found, so and so respectively. Then the opium was seized. Then in presence of 2 independent witnesses and 4 accused persons drew 1 sample in duplicate of 24 gram each and marked as S4 and S5 and D5 respectively. All the 4 samples were duly packed in polythene and then kept inside on the envelope. All the samples and the seized dark brown color sticky material suspected opium was sealed with NCB brush seal number 1 and properly labeled, and signatures of the independent witnesses. All 4 accused persons and seizing officer was also taken. The polythene bag carried by Muhammad Abdul Kalam were searched, and on opening one of the plastic bags carried by Abdul Kalam, dark brown color sticky material was found packed in 1 packet wrapped by brown color sellotape and kept in white polythene. A small quantity of dark brown color sticky material was taken out from the said packets and tested with the help of the drug detection kit, and the material gave positive test for opium.
If you are going to read the entire thing, it's going to take a very long time.
Yes. Then all the
That's the
things
basics.
then we can go directly to the cross part. Here, one important thing is that page 23, Lordship.
Yes.
Page 23, here he has stated here some mistake has been committed by this witness and the prosecution also. For the same document, marking is the same. That is why we mentioned before the court, and we file additional affidavit to that regard as per direction of this honorable court also.
EX 33.
Exhibit
EX 33.
page 23, exhibit 33. Here mentioned 33 is as office receipt of the office of FSL. 33 is the inventory under section 52A of NDPS Act that is mentioned, that was not in the paper book, Lordship. That is why we brought this thing before honorable court by finding an additional affidavit. It is in the record, Lordship. It is in the record. It is wrongly marked, Lordship. By
Anything relevant about it?
yes, Lordship.
What?
52A regarding this, he has stated, but whether it is
Or the
really
inventory?
inventory or not, that is, we need to see that line also. Because that to that regard, your Lordship judgment is also there, and the first court judgment, that is judgment also there earlier in Mohanlal also, Lordship. 52 is very much essential in every case, Lordship. Though 33 is mentioned as receipt of FSL, office of FSL, Lordship, and subsequently wrongly mentioned as exhibit 33 as inventory 52A. So for one number, 2 documents, Lordship. That is the date. That is why this is.
But if it is there, how does it matter?
No, I have to mention before the court. That is why, Lordship. Then we can go directly to the cross part of this witness, Lordship. Sorry, someone came to paper book.
I'm also there, madam.
So Lordship, cross part. In material exhibit 357, there is no
Which
signature.
page? Which page?
Page number 28, Lordship.
Yes.
Yellow. In material exhibit 357, there is no signature or any seal of the godown in charge of NCB, and godown entry number is also not mentioned in material exhibit 357. So whether they have kept in the godown or not.
What is material exhibit 3?
Material exhibit is order seized contraband, Lords.
Seized contraband.
Lords.
All the contraband or only
Contrabands, Lords.
contrabands?
All the contrabands, Lords. All the contraband, some contraband mentioned here. where all the contraband produced before the court,
Morphine and the opium,
opium,
both.
Lordship.
And 5,
3, 5, 7, they're all. the
Acha,
packets
all,
are
all.
Lordship. Then Lordship, what happened? Go down entry number, then seal number, there is nothing. Not mentioned in the material exhibit. In the material exhibit 8 to material exhibit 15, there is no signature and seal of go down inserts, nor there is mention of go down entry number. In para 3 of offense report, there is a specific mention that accused persons were indicated by the informer. On being asked, the accused person introduced themselves by their names. In exhibit 3, the proper description of the vehicles were not given. And in NCB 1, there is also mention of the truck number. So it is not a fact that the facts mentioned in NCB 1 do not tally with the facts stated in para 3 of the offense report. In NCB 1, the reference number has not been mentioned. In NCB 1, the short signature of the informer is there, but I will not disclose the identity of the informer. Exhibit 3, I did not mention the time when the information was forwarded to the superior, but I sent it immediately. Superintendent Tulika Morang did not give a separate note that she had received the information. She did not mention the time.
just one thing, is Mr. Yes, is Mr. KL coming or not?
He told me, my lord,
Huh?
because she will take later on.
Huh?
We are together in other court, my lord. So he said, yes, he'll continue, he will pay submission any other day.
Any other day?
He said, I do not know. But his representative is here, man. Ask her to not know. I do not know just what he said.
We can finish it up. The only
Letter is coming from long time, my lord. Again, coming, so we are also, my lord, your worship.
No, it's not that. You see, we don't want to hear a matter halfway and
Yeah.
leave it halfway.
But
Like-
his representative is there.
it's a,
No, representative, but they're not going to argue. There's no point. If they're going to argue, that's a different thing. There's no point hearing you only. And then we
This was
adjourn
not
the
in-
matter. There's no point.
this was not intimated to us, Lordship, because this
How long will you take?
I can finish it up in this and the PW 5, Lordship, because I have mentioned this that this main point is 52A. And the other part is regarding this 50 and the independent witness.
My lord, basically, just, I'm just interfering, my lord. What point in this case, legal point, my lord? Inventory and whether that in the 40, 43 and 52A. That is the only thing what your lordship is very much.
Why 43?
43 no,
Also, 43.
52A,
52A, capital A.
A,
It
52A,
is specific model mandatory provision application is to be filed. And after filing application, that three much are there, my lord. That they have to follow this thing. Nothing was followed, and that is appears in the from the cross examination of it appears from that file. So it is a clear, very short point otherwise, my lord, legal point.
convicted for 20 years or
Okay.
7 years.
20 years conviction, my
Convicted
lord.
in 7 years. of
Sentence
jail.
20 years. Already 7 years gone.
God.
Gone, my lord.
Student 60 months.
I'm actually-
So then why do you want to read the evidence? If that is the short
Only
point.
3 part.
So there's a basic my legal point how to just answer.
So basically section 52A and section 50, that's
50.
all.
And an independent witness, Lordship.
Independent witness.
Yes, that part, Lord.
Sida would-
Whether
So
that is
3 points.
Yeah,
3 points, Lord.
3 points.
That 3 points, whether they're in the record or not, Lordship, look into that part only. And the latest judgment and honorable court, Lordship judgment is there, Lordship. In Monil Hawk case, Lordship. Lordship elaborately discussed in this case, that case.
Then analytical discussion. your worship.
Yes.
Okay. Don't take long, but
So I will not take much time, Lordship. Should I
because
read
if we are going only on the legal aspect,
the legal aspect?
there's no point going into the factual.
And the-
No, we are not on factual, Lordship. I mentioned that thing, that the 52, the 30, whether I asked the question in this paragraph, Lordship, page number 30, Lordship will get.
Yes.
Regarding 52, Lordship is very much aware to that regard, how to follow that procedure, Lordship.
No, I'm not aware.
So then, before that, Lordship, we need to read the 52A, Lordship,
52A2.
50, Lordship.
52, subclause capital A.
uh,
52A.
Subclause two. Yes.
Close to that.
Yeah.
Subclause two, I'm reading, Lordship.
Yeah.
Where any narcotic, drugs, psychotropic substances, controlled substances or conveyances has been seized and forwarded to the officer in charge of nearest police station or to the officer empowered under section 53. The officer referred to in subsection 1 shall prepare an inventory of such narcotic, drugs, psychotropic substances, controlled substances or conveyances containing such detail relating to their description, quality, quantity, mode of packing, marks, numbers, or such other identifying particulars of narcotic, drugs, psychotropic substances, controlled substances or conveyances, or the packing in which they are packed, country of origin, and other particulars as officer referred to in subsection 1 may consider relevant to the identity of the narcotic, drugs, psychotropic substances, controlled substances, or conveyances in any proceeding under this act and make an application to any magistrate for the purpose of certifying the correctness of the number one, certifying the correctness of the inventory so prepared, or B, taking in presence of such magistrate photograph of such drugs, substances, or conveyances and certifying such photographs as true, or C, allowing to draw representative samples of such drugs or substances in the presence of such magistrate and certifying the correctness of any list of samples so drawn. 3, where an application is made under subsection 2, the magistrate shall, as soon as may be, allow the application, notwithstanding anything contained in Indian Evidence Act or the Code of Criminal Procedure. Every court trying an offense under this act shall treat the inventory photographs of and any list of samples drawn under such subsection 2 and certified by the magistrate as primary evidence in respect of such offense. So in our case, in page 30, Lordship will get that. And paragraph number 1, 2, 3, 4, fourth number paragraph, Lordship. Page 30.
Yeah.
In Panchnaama Exhibit 19, in Panchnaama Exhibit 19, Lordship got it.
Yeah.
Mention the color of the seized contraband as a dark brown color. I did not mention in Exhibit 33, that is in inventory, the mode of packing of contrabands, marking or any specific mark in the packet. I did not find any application. This is important, Lordship. I did not find any application before the magistrate for certifying the correctness of the inventory so prepared by. This is the case, Lordship. Sample must have to collect before the magistrate, Lordship. That is on the spot they have collected and that was sent to the FSM.
That's all.
That is the main crux of the case, and IO also to that regard.
What about when you read 52A, it says disposal of seized narcotic drugs and psychotropic substances. Does it have to be done at the very beginning or does it can be done?
At the very beginning, they have to do it.
Yeah. Disposal can be done at the end also.
No,
Why?
the disposal part is as per Mohanlal judgment. It is their Lordship. Disposal part is different. From the first day, they have to produce these things before the magistrate, and they have to collect the samples in presence of the magistrate with the photographs, Lordship, which is passed by the apex court letter judgment also after Mohanlal Lordship. That part is absent in this case, Lordship, by the investigating agency.
Anything else?
In this regard, IO regarding this inventory was IO part.
Page.
Lordship. IO court খুঁজিলে
Okay, so no inventory was signed by the magistrate.
Lordship. And inventory page 30, exhibit 33, I have filed in this regard, Lordship, I have filed additional affidavit for regarding additional affidavit for আমার স্যার বলে স্যার এই স্যার বলে দিছে একেল যাব হয়ে গেছে বলবো না রে additional affidavit I have filed, Lordship.
Huh?
Additional affidavit to that regard, I have filed regarding this exhibit 33. Kindly go through that. Original one is in the record, Lordship. Original one there, network. Original one there. Original.
Additional affidavit.
Additional affidavit I filed, Lord. Like is in the record.
Yes,
In there, Lordship, Lordship find these things.
Yes,
In the
I want-
original record also, it is there, Lordship. Exhibit 33. চিন্তা আমি না পাইছে ফটো এটা আছে এখন আর নাই আমার পুরোনো So as per this also, Lordship, what they have mentioned and regarding that Lordship, what they have regarding the color and powder, I have mentioned that they have stated recovered. Sorry, it is just opium the color sticky arrow with the powdery substance 850 to 80. As per this, they have as per exhibit 33, they have mentioned that they have collected powdery substance, dark brown powdery substance, and they produce before the court sticky substance, Lords. So the whole case is doubtful to that regard.
opium is usually slightly sticky.
That is why if they have sticky thing collected and all the materials are sticky, then they mention in their this exhibit 33 powdery substance were there.
You see, it can be due to the storage. Due to-
Opium is
due
sticky,
to-
Lordship.
Due to humidity in the atmosphere.
That is a seal pack they have stated.
No,
seal
no,
pack.
seal pack, how does it matter?
But think whatever they have collected at that time, powdery substance. If it was powdery substance,
Let us see the Caesar memo.
the Caesar memo also there. In exhibit. Eight, no, exhibit.
No, no, it's okay.
167, page 167. Sorry. 167 is the Caesar list. There is no mention regarding to that regard. Lordship.
Correct, there's nothing with regard to whether it's powdery or.
Powdery I found in the, in this 33, exhibit 33, Lordship.
Page.
In additional affidavit and in the original record, it is there also. Original or flag query বলেছিল।
In the additional affidavit, what does it say?
করতে। Page number, Lordship will get. What the color powder, but 262, Lordship. In addition,
Yes.
at the bottom, Lordship.
Hmm.
Deep brown color powder believed to be to the opium. In the original record also it is there. But this is only inventory they have prepared a list, but that was the formalities regarding the inventory. So that application must have to file before the court for certification of the correctness of the this inventory. If they prepared at the spot and thereafter they need to file a application before the magistrate lordship for correctness of the inventory. And sample need to draw in presence of the magistrate lordship regarding that. Judgment 52A. কি কলে? কলু। মঙ্গিলাল তো হয়ে গেল। Lordship, it is decided in 12/7/2023. Mungila.
Yes.
In this case, Lordship will get paragraph number 5, latest judgment, Lordship, it is decided 12/7/2023.
Yes.
Paragraph number 5 and 6, Lordship. Disposal manner also discussed in this case, Lordship. Paragraph 5, Lordship. Subsection 2 of 52A of NDPS Act mandates a competent officer to prepare an inventory of such narcotic drugs with adequate particulars. This has to be followed through an appropriate application to the magistrate concerned for the purpose of certifying the correctness of inventory, taking relevant photographs in his presence and certifying them as a true, or taking drawal of samples in his presence with due certification. Such an application can be filed for any of aforesaid three purposes. The objective behind this provision is to have an element for supervision by the magistrate over the disposal of seized contraband. Such inventories, photographs, and list of samples drawn in with certification of by magistrate would constitute a primary evidence. Therefore, when there is non-compliance of Section 52A of NDPS Act, where a certification of a magistrate is lacking, any inventory, photographs, or a list of sample would not constitute any primary evidence. The obvious reason behind this provision is to inject fair play in process of investigation. Section 52A of NDPS Act is a mandatory rule of evidence which requires the physical presence of magistrate followed by an order facilitating his approval either for certifying an inventory or for a photograph taken apart from the list of sample in due compliance. Section 52A(1) NDPS Act, the Ministry of the Finance Department issued notifications and so for disposal. Regarding disposal manner that has been discussed. Then Lordship come to paragraph number 8 also for destruction. Destruction part is there is Lordship. Then here, Lordship, the Mohanlal judgment discussed, Lordship, in paragraph number 9. On the issue of seizure in the presence of magistrate, we wish to place reliance upon the decision of this court, Union of India versus Mohanlal. Subsection 3 of Section 52A requires that magistrate shall as soon as may be allow the application. This implies that no sooner the seizure is effected and the contraband forwarded to the officer in charge of the police station or the officer empowered, the officer concerned is in law duty bound to approach the magistrate for the purposes mentioned above, including grant of permission to draw representative sample in his presence, which samples with then be enlisted and the correctness of the list of samples so drawn certified by the magistrate. In other words, the process of drawing of sample has to be in the presence and undue supervision of the magistrate, and the entire exercise has to be certified by him to be correct. The question of drawing samples at the time of seizure, which more often than not takes place in absence of magistrate, does not in the above scheme of things arise. This is so essentially when, according to section 52A(4) of the Act, sample drawn and certified by the magistrate in compliance
They
with
said this is so especially.
especially. This is so especially when, according to section 52A(4) of the Act, samples drawn and certified by the magistrate in compliance with subsection 2 and 3 of section 52A above constitute primary evidence for the purpose of the trial. Suffice it to say that there is no provisions in the Act that mandates taking of samples at the time of seizure. That is perhaps why none of the states claims to be taking samples at the time of seizure. Be that as it may, a conflict between statutory provisions governing taking of samples and standing order issued by the central government is evident when two are placed in juxtapositions. There is no gainsay that such a conflict shall have to be resolved in favor of the statute on first principles of interpretations, but continuations of statutory notification in its present form is bound to create confusion in the minds of the authorities concerned. Instead of helping them in the discharge of their duties, the central government would therefore do all and to re-examine the matter and take the suitable steps in the above direction. To that regard, Lordship, I would like to place Mohanlal judgment 2016 3 SCC 379. SCC. Thereafter, the Honorable Court in Mohanlal judgment, after discussing in para 30 of Union of India, Mohanlal Lordship. No, para 30, para 31. In para 31, Lordship, no sooner the Lordship.
Yeah.
Para 31. Yes. After having all discussion in that judgment, Lordship, the case is summed up by the Honorable Apex Court that the 31(1), no sooner the seizure of any narcotic drugs or psychotropic substance and controlled substances and conveyances is affected, the same shall be forwarded to the officer in charge of the nearest police station or to the officer empowered under section 53 of the Act. The officer concerned shall then approach the magistrate with an application under section 52A subclause 2 of the Act, which shall be allowed by the magistrate as soon as may be required under section 3 of the section 52A, as discussed by us in the body of the judgment under heading seizure and sampling. The sampling shall be done under the supervision of the magistrate as discussed para 15 and 19. Lordship, kindly turn to para 15. It is Lordship got it. Married. It is manifest from section 52A to C that upon seizure of the contraband and the same has to be forwarded either to the officer in charge of the nearest police station or to the officer empowered under section 53, who shall prepare an inventory as stipulated in the said provision and makes an application to the magistrate for the purpose of a certifying discussing this section, Lordship. Then Lordship can kindly come to these are the it is in the sections we read already. We have read the things. Then para 16 last the 16 regarding subsection 3 of section 52A requires that magistrate shall as soon as may be allowed the application. This application that no sooner the seizure is effected, the contraband forwarded to the officer in charge of the police station or the officer empowered, the officer concerned is in law duty bound to approach the magistrate for the purposes mentioned above, including grant of permission to draw representative sample in his presence, which samples will then be enlisted and the correctness of the list of samples so drawn certified by the magistrate. In other words, the process of drawing of sample has to be in presence and under the supervision of the magistrate, and the entire exercise has to be certified by him to be correct. So that is the thing. Then in 17, the question of drawing of sample at the time of seizure, which more often that not takes place, more often than not takes place in the absence of magistrate, does not in the above scheme of things arise. This is so especially then according to the section 52A4 of the Act. Samples drawn and certified by the magistrate in compliance with the subsection 2 and 3 of section 52A above constitute primary evidence for the purpose of the trial. Suffice to say that there is no provision in the Act that mandates taking samples at the time of seizure. Then Lordship kindly come to paragraph number 18 and 19 at the discussion. Lordship, Mr. Sina, learned amicus curiae argues that even amendment of the Act stipulating that the samples be taken at the time of seizure is not possible. At least that ought to be done is to make it obligatory for the officer conducting the seizure to apply to the magistrate for drawing samples and certification, etc., without any loss of time. The officer conducting the seizure is also obliged to report the act of seizure and the making of the application to the superior officer in writing, so that there is a certain amount of accountability in entire exercise, which as at present gets neglected for a variety of reasons. There is, in our opinion, no manner of doubt that seizure of the contraband must be followed by an application for drawing of samples and certification as contemplated under the Act. There is equally no doubt that the process of making an such application and resultant sampling and certification cannot be left to the whims of the officers concerned. The scheme of the Act in general and section 52 in particular does not brook any delay in a matter of making an application or drawing of samples and certification, while we see no room for prescribing or reading the time frame into the provision. We are of the view that an application for sampling and certification.
So yeah, reading out, we've heard, what is the point of?
This is what I have made before this honorable court regarding sampling and all 52A. Then Lordship are already in Lordship judgment. It is also mentioned Simarjit and Lordship judgment is Moinul Haq. Passed in Criminal Appeal 101/2022. Lordship judgment Moinul Haq.
All the judgment are in support of the.
2A.
Which is the only thing, strong point.
It start from paragraph number 15, notes. No, sir. Paragraph number 15. Huh? 15 or plus start কিন্তু 18 financing 15 of 50 it start from 15. Lordship will discuss the regard.
Go to the relevant
Lordship, it's a
paragraph.
18 is the relevant paragraph, Lordship. And Simarjit Singh, I am not repeating that the Lordship already peruse that in this judgment, lordship. 18 is the relevant, lordship. Should I read, lordship?
Yes.
In the present case, there is no evidence showing that the inventories of the seized narcotic drugs has been made or produced before the court of the magistrate for the purpose of certifying the correctness of inventory. No photographs were taken, no samples of the narcotic drugs has been drawn in the presence of magistrate. In case Simarjit Singh versus State of Punjab in criminal appeal, that was also latest at that time, lordship. Which was disposed by the Apex Court on 9/5/2023. The Apex Court set aside the order of conviction of the accused appellant on the ground that drawing of samples of narcotic drugs had been done in terms of section 52A2 of the NDPS, as the same had created a serious doubt as to whether seized article was contraband. So thereafter, Lord, this is the main point, Lord. 52.
The effect of not complying with 52A has not been spelled out here.
Lordship.
What is the effect of not complying with 52A?
Lordship, this is a mandatory provision, Lordship. No, because the under NDPS Act, the punishment is so severe. So all the mandatory provision need to apply scrupulously, Lordship. So severe, so stringent, Lordship. They had a conviction for 20 years. Huh? 202.
But come to para 24. No, come to para 24.
Yes. Reported in held that for proving the offense under the NDPS, it was necessary for 24. Oh, sorry. In Sahiram, the Apex Court, while considering the other decision made by Apex Court regarding a non-production of the contraband before a learned court, like in case Vijay Pandey and Vijay Jain, has held that the benefit of acquittal extended in the above two cases due to non-production of the contraband
This
material.
is not production, this is different.
Even after production of this case, Lordship Mangilal, the Honorable Court decided, the Apex Court decided that even after production of that, all the contrabands, regarding the certifying the correctness of the inventory is very much essential in the case of NDPS Act, Lordship. Paragraph 20, Lordship is 20. Lordship, kindly, there is a paragraph number 20, Lordship. Paragraph number 20, in this
No,
case.
you see, yeah, out here, it has basically been stated that 52A not complied with, but besides that, the seized contraband also had not been produced
That is in that case,
in that case. So,
but
so that nothing has been clarified here as to what would be the consequence
he produced the.
of not complying with 52A. What is the consequence? Is there any judgments
That is,
showing the consequence of not complying with 52A?
this Mangilal is there, Lordship.
Yes, sure.
I do. Right now,
Yes.
I place this, Lordship. This is a 12/7/2023 decided by the.
give us that.
5 and 6, sir. Alright, 5 and 6. Paragraph 5 and 6. Mangilal, latest. Amni ko 5 and 6. He's saying something. In this case, Lordship 4, 5, 6 regarding this 50 application of the 52A. Why we're stressing on that point only, Lordship, because here only 3-4 sections are there under NDPS Act, which are mandatory in essence. As your Lordship is very much aware to that regard. So we are not on 42 because 42 complied. That is not the argument in this case. only for 52 is 1 and a 50. These three sections are mandatory under NDPS Act, Lordship. So in our case, first first limb of submission is that 52A is not complied, they have not applied for certification. So if any violation, any mandatory provision under such type of stringent punishment, then that is the alone the ground in our appeal. So this is regarding regarding Lordship query, if 52A regarding certification of the correctness of the inventory, if not applied, what would be the consequences? In that case, Lordship, if any mandatory provision is not followed, then the accused is prejudiced in this case. Some other points also involved in this case regarding this, like that, Lordship, the charge was framed under 21C and 29, Lordship. Now, whether the case is booked under 17C, though that was not altered, but subsequently they were convicted under that section. But thing is that in 313, that question was not put.
Not charged under 17C.
No, if not 17C, then that question was not put under 313. Then they did not get any proper chance to explain that thing as per law, Lordship, what I found in this. Why, sir?
But then 17C is only the punishing section.
Whatever it is, Lordship, I don't know.
It's but you have the violation is of basically section 8.
Section, but charge is from 21C, 21C.
17C.
Punishment 20 years. Maximum 20 years. Maximum punishment need to explain why maximum punishment imposed upon the accused. Minimum up to 10 years.
Next,
Then next.
Madam, you're taking up the entire time on the afternoon. Mr.
But case is
Biswas
very
is also
serious.
waiting whole day.
This case is very serious, Lordship. They are inside 2016.
No, we have heard, but you're going round the bush. It's like a Hindi movie. We're running round and round the trees.
Then Lordship, only regarding the 50.
Yes.
50, they have issued the summon
Ah.
to the notice to the accused. Whether your
You said there was the latest judgment of the Supreme Court. Latest judgment, what is that?
regarding 50,
That was with regard to
52.
Angilal.
Yes.
Okay. Then
Then latest judgment is
with
regarding
regard to section 50.
50.
Yes.
Regarding 50, yeah. Regarding 50, Lordship, latest judgment. Mix up with 50 judgment. A to first, latest to A to among the and it is open. It is, I'm extremely sorry, it is three judges judgment lodge, 3 bench judgment lodge. 82, Sanjeev. Regarding 50. First of all, Lordship, if their argument before the trial court was that, Lordship, if recovery not from body, then 50 will not applicable.
Correct.
But the latest judgment is that, Lordship, regarding section this, Lordship will get in paragraph number 9.
Nice.
We have checked the original record. Lordship got it.
Yes.
Check the record to satisfy ourselves. Exhibit 8, these are the exhibits which are arrest memos do not reflect that any options and choice was given to the accused before their personal search was undertaken. It is true that personal search did not result in recovery of any contraband materials, but non-compliance of requirement of affording an option was one of the reasons which weighed with the trial court in disbelieving the case of prosecution. So in this
That
case,
doesn't say anything.
But here lordship, personal search was there. So considering that aspect, there if section 50 is
No, this does not help you. How does this help you? I fail to get. I fail to understand how it helps you.
then one more judgment is there, lordship, 2014 or Paramananda. 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 Paragraph number 14 and 15, lordship. Paragraph 14, lordship, Union of India versus Shah Alam. Heroin was first recovered from the bags carried by the respondent dairy. Thereafter, the personal search was taken, but nothing was recovered from their person. It was argued that since personal search did not lead to any recovery, there was no need to comply with the provision of Section 50 of NDPS Act. Following Dilip, it was held that since the provision of Section 50 was not complied with, the High Court was right in acquitting the respondent on the ground. Thus, if merely bag carried by a person is searched without there being any search of his person, Section 50 of NDPS no applicable. But if bag carried by him is searched and his person is searched, the Section 50 of the NDPS Act will have application in this case. Respondent 1 Paramananda's bag was searched. From the bag, opium was recovered. His personal search was also carried out. Personal search of respondent 2 Surajmal was also conducted. Therefore, in the light of the judgment of this court mentioned in the proceeding paragraph section 50 of the NDPS Act, will have the obligation.
I don't know. There are judgments. They are different. They are the judgments of the Supreme Court saying otherwise.
A latest judgment, lordship, we can produce the latest judgment. I got it in the morning, lordship. I can place that one also regarding that, lordship. And one last submission to that regard, lordship, regarding independent witness.
And
That is-
in any event, first of all, there are conflicting judgments to this. And in this case, they had given there no objection to being searched. So where does the
No,
question
no,
of
to that regard, lordship, this constitution bench judgment is that if once they body search, notice issued, and they said that you can search, then they gave consent to the officers. In that case, it is the duty of the officer to produce the person before the gazetted officer, independent gazetted officer. That judgment by the constitution bench judgment is there, lordship.
Yes, but then was it your case that you were not searched before that?
No, I was not charged before any.
And is it your case that you wanted to be searched before the gazetted officer?
If accused is silent, there is mention, if accused is silent and accused gave the consent.
You have given a consent in writing. You have evidence
In
of
writing
that.
also, if accused, that is there, lordship. As per judgment, I'm making this submission, lordship. So.
Was personal search conducted
Yes,
in your case?
yes.
Personal search was conducted
Yeah.
after you giving your consent in writing.
That needs to explain in this case, lordship. If I gave any permission to the officers to search my body. In that case, the duty of the officer to produce the person before the magistrate.
No, no, where's the question of producing the person? PW3 himself has stated it.
No, he is not the independent gazetted officer, Lordship.
It doesn't require.
It is required, Lordship, it is required, Lordship, as per the constitution based judgment, Lordship. You know? If he is the member of the raiding party, he cannot charge the person. Independent gazetted officer is required, or magistrate, independent magistrate.
No, but then if you give the consent,
In that case also,
then
in that case also, it is the right of the accused to produce before any gazetted, independent gazetted officer, Lordship.
I doubt. Anyway,
But there
please
is-
give the judgment. Let us see. Give us the
Sir,
judgment.
can I place?
Give the
all-
judgment. No, no, you just give it to us. You've already given us. We have heard you.
Yes.
Yeah, we told you sometime back you still wanted to hear. We're hearing you. You give us. There's no point now. The compilation is not required.
একটু listen কর। আচ্ছা, আচ্ছা, একটু listen কর। হ্যালো, একটু listen। একটু দেখুন আচ্ছা একটু দেখুন Sexually violent before the general মানে একটু কি বলবো একটু দিতে হবে my lord 2011 6 SCC
I
390
thought you said the latest the constitution bench judgment.
latest judgment lordship that one I produced before
Okay, 2011,
2011 6 SCC 392 lordship.
392.
Here, Lordship, paragraph 5, it appears that requirement of section 50 of NBSS is not complied with by merely informing the accused of his option to search either in presence of gazetted officer or before a magistrate. The requirement continues even after that. It is required that the accused person is actually brought before the gazetted officer or the magistrate, and in para 32 of Constitution bench made it clear order to impart a authenticity, transparency, and creditworthiness to the entire proceeding, and endeavors should be made by the prosecuting agency to produce the suspect before nearer magistrate. This is Sukhdev. Editor. Paragraph 6, 5, 4 and 5. Vijay Sanders, একটু দিব পারা যায়নি দিতে একটু আসলে কোডগুলো এইটা এটা তিনটা জায়গা আছে মিল যাবে ভিডিও তিনটা জায়গা আছে latest one again, কালকে পাঠাই দিও তো মোবাইল নাম্বার
An endeavor should be made. It's only an endeavor. If it cannot be done, it doesn't vitiate the trial at all. It's only an endeavor. This aspect has been clearly clarified subsequently.
একটু কিছু জাজমেন্ট যে আছে একটু নতুন আইছে তুমি ডাউনলোড করতে পারেন latest judgment I couldn't download. I can place this on lordship. It is decided on 30 August.
Anything else?
Support.
Basically, that will result from Basically, my lordship will take up the very background of this section 52A. Your lordship is having that copy, my lord.
Basically, that para 5, 6 and 9.
Yes, no, my lord, scope are discussed. While discussing, it is stated, my lord, that paragraph 6, my lord. Obvious reason behind this provision,
Para 6, 5, 6 and 9.
yes, that's it. So it is written is mandatory rule of evidence, fine. So that's much as because ultimately your lordship is aware, my lord, stringent punishment, stringent rule is to be followed. This is the basic thing, my lord. We are completely matter than solely on that 52A, my lord. And second limb of is my punishment, my lord. Not less 10 years, it may extend to 20 years, my lord. So that is the second limb, my lord, that here. Second question, my lord, our second point of argument, my lord.
That,
That second point of argument is that, my lord, what sentence is also 20 years sentence was given without justifying the 20 years. My lord. So basically, so 52A is mandatory, my lord. Once it is non-compliance, it is to go. Whole conviction will go, my lord. So this is basic, my lord. Rest is your lordship, my lord.
okay. Yes.
Yes, go.
Huh?
That
That is what you said he was coming. That's why we heard them. Now you see one thing. If we leave it like this, then by next week I'll have forgotten everything they have said. And then we wasted 1.5 hours. Other cases we could have done, disposed of. And then you all said that he will come in the meantime. They will start. Wasting their time, our time, court's time, everyone's time.
I had also other case, I had to leave that case, I had to come here. Because that is a senior court.
What is
order.
it? That was the reason in the very beginning we had said whether you couldn't do it or not. This is not the way to behave. That's why I don't like hearing only one side and the other side is not here. This happened. Now the issue is already that small issue now.
Yes,
4 points. Actually 4 grounds I think.
yes, yes, man.
When do we pass appropriate orders? We have got to. We cannot. This is not like this is not a private company. I can do as I like. It's not my private house that I can do. I'll eat chicken today. Tomorrow I'll have puri or something like that. I can do as I like. Nothing like that. I have heard them. I have to hear your side also. It is a crime against society, not against you personally. If you say that, okay, if it's a money suit between you two, you say you can give everything. I don't need anything. That's a different thing. But this is not you. This is the society. And yeah, why do you come to court at all? You should have told us in the beginning that you will not be able to hear the matter, give your submissions today. We could have adjourned the matter. The other lawyers are waiting. Mr. Acharya and all, we had given them today. Right. Heard Miss S.K. Nargis, learned counsel for the appellant in criminal appeal number 360/2019 and in criminal appeal 393/2019. Mr. H.R.A. Chowdhury, learned senior counsel, appears for the appellant in criminal appeal number 288/2019.
My lord, in all cases, my senior will be led this case.
Okay.
I am assisting. him.
Okay, so you just write, Mr. H.R.A. Chowdhury, Learned Senior Counsel, appears for all the appellants,
Assisted by.
assisted by Ms. S.K. Nargis. Full stop. No one appears for the standing counsel for the NCB is absent. Despite his juniors having stated that he would come during the hearing. Full stop. This appeal has been, these 3 appeals have been filed
On behalf of 4 persons, my.
by the appellants Ram Milan. Who is the other one? Ram Milan? Ram Milan.
Ram Milan,
Ram Milan Saurabh Khan. No, Ram Milan Mohammed Mujibur Rahman. MD Mujibur Rahman, comma.
Ram Milan,
uh,
Abdul Kalam,
Abdul Kalam and Saurabh Khan.
and Mujibur Rahman.
Against the impugned judgment dated 22/4/2019 passed by the District and Session Judge, Kamrup M, Guwahati in NDPS case number 38/2016, by which the appellants have been convicted under section
21C.
17C/21C.
and 20.
That's all.
And 20.
21C and 17C, my.
That's all.
17C and 21C. Lordship.
That's all. The 17C and 21C. NDPS Act. In connection with the recovery of 54.648 kgs of opium and 2.060 kgs of morphine. The appellants were sentenced to undergo a rigorous imprisonment for 20 years and to pay a fine of rupees 2 lakhs each, in default to undergo a rigorous imprisonment for 1 year under section 17C NDPS Act and to undergo a rigorous imprisonment for 20 years each, and to pay a fine of rupees 2 lakhs each, in default to undergo rigorous imprisonment for 1 year under section 21C.
No, my lord, 17 1 year.
No. 17 also 20 years,
No,
21
that-
also.
You got imprisonment for 1 year for committing offence under section 17C, page 140. Page 140, my lord, of the paper.
Where are you reading 1 year?
Affirmative part, my lord, 17C 1 year and 21C 20 years.
Not in my copy.
My lord, this paper book,
In paper
the
book,
one-
page number.
last part of the.
Come to para 93.
No,
Yes, sir.
I'm saying that from the order of the judge, my lord.
Education.
Yes, paragraph 93, my. Paragraph 93.
It says 20 years.
No, my lord, 20 years each, fine of so in default to undergo examination.
1 year.
Yes, in default. That is in default 1 year.
Yeah.
Okay.
Sometimes because of age, my lord, I was.
Ah.
Sometimes.
It's okay, it's okay.
It's my problem.
No, it's okay, it's okay. Like you said, maybe age, maybe. It's not age, happens. It
Time
happens.
is also minor.
No, it happens. Sometimes because it's so confusing sometimes. That's why. So what have we said? Madam? Same, huh? Same. Okay, that's good. Same amount. Ah, 1 year again, under section 21C NDPS. You all had said that remission would not apply.
Yes.
Remission, Lordship.
There is nothing here to that effect.
So when here,
Remission after, from 10 years.
not less
Not
than 10
less.
years, may extend to 20 years. Fine.
No.
Remission from 10 years.
No, but out here you said that the remission would not be given, but there's nothing stated to that effect.
Yes.
Okay, next, full stop. The brief, the prosecution case in brief is that on the basis of an information received by the NCB that MD Abdul Kalam and MD Mujibur Rahman would be delivering a consignment of morphine and heroin, morphine and opium to MD Saurabh Khan and Shri Ram Milan near Indira Gandhi Stadium, Saru Sajai Guwahati on 7/5/2016. A team comprising of intelligence officers was constituted to intercept the said transaction. Wisdom. On reaching the spot, the enforcement team saw a Scorpio vehicle bearing registration number W58C2517 parked on the road. At around 6:30 AM, truck bearing registration number MN04A 1960 arrived near the Scorpio vehicle. Thereafter, two persons, namely two persons came out from the Scorpio and went to the truck and went to meet the two persons who came out from the truck. After the four persons had some discussion, one person entered into the cabin of the truck and handed over few polythene packets to the person standing, to the other persons. The NCB team thereafter rushed towards the four persons and detained them along with the polythene packets, which were in their hands. The search of the search and recovery of the contents of the packets reveal that reveal the presence of that sense of kgs of morphine and opium. Next paragraph. The learned counsel for the appellant submits that Sarab Khan and Ram Milan were the occupants of the Scorpio, while Abdul Kalam and MD Mujibur Rahman were the occupants of the truck. Next paragraph. The learned counsel for the appellant submits that the challenge made to the impugned judgment passed by the learned trial court is basically on 4 grounds. So firstly, while charges had been framed against the appellants under section 8 bracket C /21 bracket C and 29 of the NDPS Act, comma, their conviction had been made under section 17C /21C, 17C and 21C. He submits that there could not have been any conviction under section 17C NDPS, as no charge had been framed under 17C. The second ground of challenge to the impugned judgment is on the ground that the NCB did not comply with the provisions of section 52 capital A bracket 2 of the NDPS Act, and as such the same and as such the mandatory provision of law not having been followed, the same vitiated the prosecution trial, and consequently the prosecution case, and consequently the trial was vitiated. In this regard, he has relied upon the judgment of the Supreme Court in the case of Mangi Lal versus
State of Odisha.
State of Madhya Pradesh, criminal appeal number 1651 of 2023. And bracket, you relied upon the case of number 1, you put number 1, case of number 1, then I'll give number 2 will be Narcotics Control Bureau. No, sorry, not this. Would be will be Union of India versus Mohan Lal and another, 2016 3 SCC 379 bracket para 31. Number 3 will be Uh, the division bench judgment of this court in the case of Moinul Haq versus the state of Assam, criminal appeal 101/2020. Next paragraph. The third ground of challenge taken by the appellants to the impugned judgment is on the ground that though a search had been conducted on the body of the appellants and on their bags and bag/packets, section 50 NDPS had not been complied with. He submits that non-compliance with section 50 NDPS rendered the search, recovery and seizure of the contraband drugs as illegal and vitiated. In support of his submission, he relies upon the judgments of the Supreme Court in the case of state of Rajasthan versus Paramanand and another, 2014 5 SCC 345 bracket para 1415. Number 2 will be Sanjeev and others versus state of Himachal Pradesh, 2022 6 SCC 294 paragraph 9. And number 3 will be Narcotics Control Bureau versus Sukhdev Raj Sodhi, 2011 6 SCC 392 paragraph 5. First one. Next paragraph. The fourth ground of challenge taken by the counsel for the appellants to the impugned judgment is that the two independent witnesses who were Caesar witnesses were not examined as prosecution were not examined by the learned trial court. In view of the fact that summons that had been issued to them for adducing their evidence, had been returned with the note stating that they were not available in their addresses. The learned senior counsel submits that it was the duty of the prosecution to produce the two independent witnesses, and the non-examination and their non-examination would have required the learned trial court to acquit the appellants, as it could not be proved that the seized contraband had been recovered from the appellants. That's right? Full stop. Next paragraph. Besides the above, the learned counsel for the appellants has also clarified that the learned trial court had inadvertently made a mistake, had inadvertently recorded, had inadvertently exhibited two documents as exhibit 33, EXT 33, which were the receipt, which was the report, is it the report of the FSL? Or what is that?
You thought it-
Report of the FSL and
Which was the report of the FSL and the
inventory.
inventory made under section 52A NDPS. That's all. Anything else?
About sentence part, madam.
Huh?
About the maximum sentence, not just. Nothing was said about the maximum sentence. What
Okay,
also?
so stop. He also submits that the learned trial court had a duty to give reasons for
Awarding maximum.
awarding the maximum sentence to the appellants under section 17C and 21C NDPS Act. However, no such reason, however, no reason has been given by the learned trial court. That's all.
She said about the conduct also, report has come that conduct also very good in the jail.
But conduct,
Well, not on the jail, no previous.
What all this, previously there is no conviction,
but no reason.
no antecedent of that man,
That report.
Right, anyway, right.
no antecedent.
Next para. As stated earlier. No, what do I do?
Giving. It is on.
We'll put that first part of the order, this part you type it separately, otherwise it'll take too long. As the standing counsel in NCB is not present in the court today, list the matter again. When? After? When will you be free?
Why not again?
When will you honor us with your presence?
Monday, Tuesday, why not, because
Monday, we've got too many cases. Full.
Tuesday,
Tuesday also, we have got fixed matters.
next week, matter, I think, matter, again, we will also forget everything, man.
Okay, this is the matter on Thursday.
After date here, say. Date to this, 12, huh? If my lord, any other judgment there also might be divided to my lord. Yes.
There's
Obliged.
this is just the beginning. 16 and 17, right, as the standing council NCB is not present, the matter is adjourned for a week.
In that case, Lordship, 15 years conviction was there, Lordship. Already 9 years completed, Lordship.
No time now,
So,
man.
I'm not going to start that. Lordship.
Even if you start, we can't hear you now, especially when they are absent.
I can give up.
I got it.
Oh, I see. That is-
Mahamori boli so. My lord, in cardiac case, can I place all the judgment in compiling? the sets?
Doesn't matter. No need. This is all.
Point, I will ask that one. Only brief point.
If necessary.
We'll see, it's, you can give some other new judgments, whatever. I don't know.
Yes.